Please join me. Please join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. I call this meeting of the Crook County Planning Commission to order. Today's date is March 25th, 2026. The time is 4 o'clock. I would like to talk about our process. The meeting is being conducted in person as well as by phone and Zoom. This allows Planning Commission members and or members of the public to participate in person or remotely. For members of the public, please wait until you are recognized by the chair to offer comments and or testimony. For those online, if you'd like to speak, please submit a request in the chat function and wait to be recognized. We'd like to thank everyone for their understanding and patience. Many minutes and audio recordings will be available on the Planning Commission website. The people joining me are your Crook County Planning Commissioners. We are volunteers that have been appointed by the Board of County Commissioners and make up a diverse cross-section of the community. The Planning Commission will consider the following agenda items. 1 is the consent agenda. 2 is continuation for deliberations only. 217-25-000-293-PLNG. 3, public hearing for 217-25-0000400-PLNG, a comprehensive plan amendment. And 4, community development updates. Next is roll call for planning commissioners. Kirk Giovanni. George Pont.
Here.
Monty Kurtz.
Here.
Michael Warren.
Here.
Quita Steck.
Here.
Marla Dill.
Present.
Hunter Newhart this year. Will staff please indicate the record which absence or excused? We don't have any. So now we're moving on to public comments. Is there anyone in the meeting room or participating remotely that wishes to address an item not on the agenda? If attending remotely, please enter a request to speak in the chat function. Oh. Good afternoon, Julie. Good. Yeah, please state your name and address on the record.
Julie Thompson, 5950 Northwest Green Valley Road in Prineville. And I wanted to first off start by thanking you guys for taking time to listen to us. And I'm going to read from my phone because this was kind of last minute. So, so I know that you guys understand the, that how this issue with the mine has affected us, our families, our neighbors, for the last 4 years. And it seemed pretty clear from the last meeting 2 weeks ago that the planning commissioners understand that this is an extremely important and serious matter for the county. And I think that you guys aren't taking it lightly, and I appreciate that. So that said, I want to make sure that the planning commission and the county staff continue to treat this with urgency that it deserves. And everyone knows that we haven't been able to trust our drinking water in years, but what you might not know is all the other ways that the mine has been affecting our quality of life. I brought with me this stack of paper, or code complaints is what it is. All of these are complaints that just a handful of us in our area have filed. We did not have time to do a public records request to actually get all of them. These are just some that a few of us got together and put together. Every one of these documents is an example of Knife River failing to follow the terms and conditions of their CUP, from parking, noise, dust, traffic, farmland reclamation, and the list goes on. So this has been a truly heavy burden for myself, my neighbors, and our community to continuously have to monitor the activities of Knife River. So again, I hope that with your help and leadership, the county can begin to take this burden off of us and take responsibility for protecting this community as soon as possible. And if you would like, I can leave these with you tonight to look at, or we can present them at a public hearing or when it's time for a hearing, I guess. There are in this stack alone 83 compliance reports that we have filed. And this has only been over the last, I think, 2.5 years that we actually knew we had to file them. with the compliance report. Before that, people were calling and emailing. We found out that wasn't proper channel. It didn't count. And I have listed them all out, how many that we have in this stack for each CUP rule, I guess is what you would call it. Like the settling ponds on EFU land, there's 5 of them filed. Operating outside of ordinary hours, 3. Dust, we had 1. I think there's more. We just didn't get the public records on that. So missing trees, dead trees, there's 16. Reclamation of the farmland, there's 10 of them. Dewatering, 5. Testing the surrounding wells before dewatering, 12 of them. Mining ponds backfilled with offsite material, 3. Vector control, 7. Weed control, 8. Parking on the roadway, 7. Ingress and egress violations, 1. And barriers or gates at access points, we have 5. So I don't know if you guys would like these tonight or if you would like to wait and receive them later.
Well, thank you. So are those all individual packets or are they, do we have them digitalized?
I have them. There's a copy of the CUP with each thing that we've highlighted in here that is violated, on the, like with where we filed a compliance report. And then they are paper clipped in groups of each violation.
Okay, I would probably recommend for staff that receive the paperwork in the future. I think it's moved to us, or can we take them now?
I can take them now. Obviously the county has records of these since we're filed with the county. We have a pretty full agenda tonight. At the next hearing we have, I'm going to bring my staff recommendation as far as what to do. Again, all parties have their due process rights here. The time for the planning commission to really thoroughly review those would either be at the time of my staff report, or if you guys decide to go with the modification proceeding, that evidence would then be useful in your decision-making process.
Got it. Thank you. So, thank you, Julie. We really appreciate it.
Yes. You want me just to leave them?
Yeah, John, would you like them?
You.
Give them to me. I'll give them to him.
Okay.
Oh, we have somebody online who wants to speak. Be Robin. Can you hear us, Robin?
Yeah, good afternoon, planning commissioners. I would
Oops.
turn on my video, but it looks like I can't. But this is Robin Hayakawa. I'm a staff attorney for Central Oregon Land Watch. Our address is 2843 Northwest Lolo Drive, 200 Bend, Oregon, 97703. Sorry I couldn't make it in person. I'm getting over a cold. But I don't have too much to add here, and I agree with John. You've got a crowded agenda and a lot of important matters in front of you. But I just wanted to thank the Planning Commission for the conversation we had 2 weeks ago, and the urgency and clarity about the issue. And then, of course, I wanted to thank county planning staff for making room in their crowded work plan for this. I think it's really important, and I hope that we'll look back at this as a really good decision for Crook County. So, with that, thank you for your time.
Thank you, Robin. Do we have anybody else who would like to speak? Nobody else online? Okay. Hearing and seeing none, we'll now mute all lines and those who are not staff or commissioners, and we'll move to the first item on the agenda. One is the consent agenda. The first item on our agenda is the consent agenda. Items on the consent agenda are considered routine and will be enacted by one motion. There will be no separate discussion of these items unless a commissioner or a member of the public requests that a specific item be removed for separate action. Does any commissioner wish to pull an item from the consent agenda for discussion?
No.
Nope. Is there any members of the public who wish to pull an item from the consent agenda? Okay, seeing none, the chair will entertain a motion to approve the consent agenda as presented.
Mr. Chairman, I move we approve the consent agenda as presented.
Second.
Okay, a motion has been made by Commissioner Steck and seconded by Commissioner Kurtz to approve the consent agenda. We'll call for a vote. Kirk?
Aye.
George?
Aye.
Laquita?
Aye.
Monty?
Aye.
Marlo?
Aye.
Michael?
Aye.
Hunter is aye. Unanimously, we vote saying 7-0. Now we'll move on to part 2, continuation for deliberation only. We'll now move to the next item on the agenda, a continuation. Okay. Record number 217-25-000-293-PLNG. Alexander Ranches LLC, who's the owner, Harmony Towers and Verizon, who's the applicant, and ACOM Consultant, which is the agent, are proposing a telecommunication facility. The subject property is located on Southwest Williams Road, north of Highway 126, and is identified as map tax lot number 151-414-0000100. The hearing is being held pursuant to Crook County Code 18.172, which is the administration provisions. The Planning Commission will be evaluating the request against the following applicable criteria: Crook County Code 18.16, exclusive farming zones, EFU 3, Crook County Code 18.124, supplementary provisions, ORS Code 215.283, ORS Code 215.275, and Crook County Comprehensive Plan. Do we have any commissioner members who have a conflict of interest or bias to disclose?
No.
Nope.
No. Has any members of the commission had any ex parte contact with the applicant or any members of the public regarding this matter?
No.
No. Commissioners should disclose if they visited the site and state on the record any observations and impressions from the site. Kirk?
I drove by it.
Okay. George?
I have not visited the site.
Laquita?
No.
Monty?
No.
Mike?
No.
And Marlo?
Not specifically, no.
And I have not. Are there any members of the public in person or participating remotely who wish to challenge any members of the commission? If participating online, please enter a request to speak using the chat feature. Hearing none, we'll move on. We will now proceed with staff's presentation.
Thank you, Chair Newharth. For the record, John Eisler, Community Development Director. Thank you, Hannah. All right, so at the last hearing on this is the final one. I'm not taking any testimony. This is for deliberations only after my report. I submitted a staff report a little bit late. It was similar to the last one, but as you hopefully noticed, it applied the tests with the evidence that was in the record. There may be more items in the record that I did not identify. So as you go through this, make sure you guys make any notes that you can. I'm going to try to get to the meat of this as quick as we can because I know we got a lot to go over and there's a lot of evidence here. So next slide, please. So broad summary, Harmony Towers and Verizon Towers, they're seeking to expand coverage in the Palo Butte community. Their goals are to increase capacity and coverage along Highway 126 between Redmond and Prineville, proposing 150-foot monopole, 9 panel antennas, auxiliary equipment, 3 equipment cabinets, and a backup diesel generator. There you go. There is the sketch of it. Next slide. Again, this is a repeat. So these are approved in resource zones under 215, 283, 1CA, which means it's a Brent Mar use. Next slide. And so here is the applicable statute, ORS 215-275. We've gone over this quite a few times now. Next slide. And so broadly, again, the applicant needs to show that the facility needs to be sited in a farm zone, and they have looked at reasonable alternatives, and those reasonable alternatives are eliminated due to one of these factors, which primarily here include technical and engineering feasibility, or the proposed facility is locationally dependent, which means in order to work, it needs to, there are unique geographical needs that cannot be satisfied on other lands. Next slide. Yeah, so as I mentioned in the staff report, I did change some things in there. I did add some bits and pieces, but the main change is the application of the factors, which organizes the arguments into the test versus the other section lays things out chronologically. Once my staff report is done, you guys are tasked with deliberating and making the ultimate findings for each of those test elements in order to make a final decision. So I'd ask that you guys identify exhibits or specific arguments that you found persuasive in your decision. And as you deliberate, let everyone know why you found those arguments persuasive. Next slide. So here's the test. Test number 1. Do the applicant's defined objectives further the statutory purpose of providing utility service? Number 2, have reasonable non-EFU alternatives been considered? And number 3, have each of those alternatives been ruled out by one or more of the ORS 215-275 sub 2 factors? Next slide. Again, so this was inserted into the staff report. It was also in one of my previous memos, which was incorporated in the staff report, but for ease of use, I put it in there. I forget which page. But the burden, as always, is on the applicant to establish all the relevant criteria have been met. The Planning Commission, as the finder of fact, is to weigh all the evidence in the record and make a decision as a, quote, reasonable person would. With competing expert testimony, your job is to determine whose testimony is more credible. And what is important is to articulate how and why the Planning Commission came to the decision that it did. Slide. So starting off with number 1. Do the applicant's defined objectives further the statutory purpose of providing utility service? Slide. So again, the staff report itself has more, it's more thorough, but this is going to be a broad overview. So the applicant's defined objectives are to increase capacity along Highway 126 between Redmond and Prineville, to expand coverage to the Palo Butte community, particularly north of the highway along Williams Road. And they have stated that this is primarily a capacity site with a low band coverage problem, which would be solved by increasing the mid-band capacity in the area. Next slide. So the main evidence presented to support this is in Exhibit 211. It's Ferguson's new ditch rider rebuttal, in that there's a variety of evidence, but some of the main stuff is the ASEU capacity graphs and the best server plots for the low band capacity. Within that exhibit, there is a new search ring and a covered objective area. It speaks of the need for the site because of the overlap now that exists between Wiley and PBS towers. And it describes the long-term plans to down tilt Wiley and PBS and add further facilities, at least one over near the airport. Next slide.
John, on that last slide there. So the Wiley Tower, right here, it states that it's not a driver for the proposed site. Is that?
So if you remember correctly on the original application, so great time for that question. So the original application, the capacity charts there were different. At that time, McCoyne was the one that was overburdened. And then you can see there where they turned down McCoyne. So before McCoyne was turned down, Wiley was not a driver because Wiley had plenty of capacity. Even said there's plenty of capacity, so we're not even worried about it. But I think in September of 2025, they turned down McCoyne, which then put the new strain on Wiley. And so originally, the stuff that's submitted with the application, the Ferguson's report in the application, at least with this chart, is no longer relevant because everything's different. So now this is the one that we should be leaning on because this reflects the most current information.
Is it going to get you off track if I have another question for you?
Yeah, go for it. That's my job.
On our ring.
Yeah.
When was that ring established?
So in the beginning, they submitted, I think that's in there somewhere, a focus zone, which, it's not in the statute that it has to be. Yeah, so it was a square. And so that's what we were kind of relying on. There were a few other, they described them as polygons that showed various things, but they weren't their official search ring, which was submitted with this Exhibit 211.
And it is the odd shape.
No, the search ring is spherical.
Spherical.
The odd shape is the coverage objective area. Oh, wait, you're right. No, the search ring is not spherical. It is odd shape.
It is odd shaped. Okay, thank you. I thought, yeah.
Odd shape polygon.
And it leans significantly to the east of the proposed site.
And
We'll touch on.
we'll get there.
Okay, thanks.
All right, next slide. And so further, this is part of the new alternative site analysis, but within the drive test report, post McCoyne being turned down. And so here it shows the drive test data for Verizon, AT&T, and T-Mobile, and it includes both the 751 megahertz and the 2100 megahertz bands, also known as the low band on top and the mid band on the bottom.
And just to be clear, they want the low band to be increased, right? Is that what they,
Not exactly. So the issue is a low band issue. My understanding of the material. So it's a low band issue, but is resolved by increasing the mid band capacity.
Okay.
So here this gets to their first, the primary need, which is, like they said, it's a capacity site. So the applicants say there are capacity constraints among the three towers. McCoyne Tower to the north has been optimized, which means turning it down, which means basically decreasing the amount, the geographical area that it covers. So it's looking down instead of looking forward, which means that then the other ones further south, PBS and Wiley, need to increase what they're providing and increase their coverage. And so after McCoyne has been turned down, the applicants say that strained the Wiley and PBS towers. And as I stated a minute ago, it's a low band problem solved by more mid band capacity. And they need a dominant WCF to minimize the frequency noise. Opponents have countered, among other things, that there's very little data supporting capacity needs, and almost all what is there is for the low band. The data presented can't be trusted because arguments that the drive test results and some of the other maps were identical between pre-McCoyne being turned down and post-McCoyne being turned down, and that the area to the north is all EFU, so it won't grow in population, so the focus should be on the highway area, and broadly that Verizon's plans are part of a grand change to the network, which would involve closer spaced towers for high-speed internet and underutilization of the existing boomer towers. And it's in the staff report, the boomer towers are PBS, Wiley, and McCoyne, the big, tall existing towers. As far as increasing coverage, the applicant says the problem, as I was stating, is mostly north along Highway 126, along Williams Road. The issue is mid-band frequency and distance from existing towers. The mid-band doesn't cover as far as the lower band, and so they need more towers. They need a dominant WCF there in the middle between the three towers. And like I said a second ago, the coverage maps didn't change because once they turned down McCoyne, they then had Wiley picking up that extra slack. And so it made the maps look the same from before and after. The opponents have countered that the coverage in the area was fine in Ferguson's original report. They really only have data presented on the low frequency bands, and the data that they do have should not be trusted because, like I said, it did not change pre and post McCoyne. It's all right. Go ahead, next slide. All right, so test number 2. Has the applicant considered all reasonable non-EFU alternatives? Right, I guess, has it been a good faith alternative consideration? Next slide. So it's the zoning of the region. You can see it's mostly EFU. Next slide. There's our search ring. Right there is the one on the left. Oh, actually, it's in both. It's the black. So that's the search ring. And then the coverage objective area is the outer red band. You can see the highway there. All right, next slide. So the alternatives presented by the applicant, in the original report, they looked at the Sprint American Tower, also known as the ATC Tower, the existing Wiley and Powell Butte South, which is what I term PBS, the existing towers, and they looked at new towers, alternatives 2. They supplied alternative 2A later on, alternative 3, alternative 4, alternative 5, and alternative 5A also came later on. And then the opposition presented alternative sites A through I, as you can see there on the map. Next slide. And so the discussion was, why is the search ring where it is? Why is it so small? The applicant, through Ferguson, has said that the new site has to be able to eliminate the existing overlap area. So as you can see there, what that triangle represents is where you have both the Wiley and PBS towers transmitting, and so there's an overlap which causes interference. And so the new tower needs to eliminate that and also cover a significant portion of the red marked squares. And then it needs to be able to extend coverage to the Crooked River Canyon and Highway 126. Next slide. So the arguments for the good faith effort to consider these reasonable alternatives. The applicant, like I said, they said need to address the overlap, and it needs to be centrally located in order to balance the load on all three sectors. Opposition has said, among other things, that the search ring that was presented was rigged. It's too small. It covers 36 tax lots, all on EFU ground, and just happens to be centrally located over, or the subject property just happened to be centrally located around that search ring. That the coverage objective area was drawn intentionally that just barely excludes two of the opposition's alternative sites, and that in order to solve the applicant's defined objectives, both the search ring and the coverage objective area should have been further south along the highway. And that information is in your staff report. Next slide. Test number 3 includes those factors in sub 2, and it also has the cost considerations. Basically, the cost can be a factor on considering alternatives, but it can't be the only factor or the deciding factor. Next slide. And so the evidence here is the second that you should lean on is the second alternative site analysis. In the original application, they also did the alternative site analysis for the PBS and Wiley towers. That was not part of this alternative. This alternative considered the ATC tower along with the numbered towers and the ones that the opposition brought forward. And then the analysis for 2A and 5A, like I said, those came later on during the rebuttal period. Next slide. And so this is the meat of it. Again, there's more detail in your staff report. I encourage you to look at that. But so the this table here shows basically the arguments on both sides. And so the applicant eliminated the Sprint American / ATC tower because it's outside the search ring and that it is too tall. It would cause interference with the other towers and not really solve the problem. The opposition has said on that ATC tower that it's just as good as the proposed site at a lower cost, and there was no consideration in placing the antenna at a lower height. And then also, I believe it was Commissioner Kurtz that brought up the idea of doing that with in conjunction with one of the alternate towers. As you can see there, Wiley and PBS, those were too far away and couldn't provide the power per link. And the opposition said they never really established what that means or what those qualifications were. And then we can walk through any of these. If you guys have questions on these, we can walk through these slowly. But alternative 2, too far south to provide coverage to the north. I believe it was Shine Fine that said that was reasonably equivalent to the subject property. Alternative 3, they're saying there was the HOA prohibition initially, but it would, and then the opposition said that would offload McCoy just as good as the subject property. Alternative 4, too far south. You can read all that. Alternate 5, they originally stood at the 25-foot height limit. On the next slide, I'll show you. They then ran the same test at 199. For a lot of these alternative site analysis, this goes for all these. They will run what's called the best server plot, which meant that so it had McCoy, PBS, and Wiley running at full capacity. So that showed how the other towers would then interact, but since it was done in that manner and not with McCoy turned down and as the system would be envisioned to run ultimately once a new tower got put in place, that those results then skewed the maps because it would show basically PBS and Wiley being too strong, which would then understate the effect that these alternate towers would have. So that argument goes for all of these. Next slide, please. And again, you can see here, some of these got more focus than others. And then they ran further tests on alternate sites 2A and 5A at 199 feet. The arguments there were again that it would give an uneven distribution among the three sectors. I believe it was alternate 2A, the opposition said the coverage there, according to the charts, was almost the same as the proposed site, and therefore capacity should be just as good. And then I think alternate G was the one with the HOAs or the CCNRs. And again, for all the rest of these, the opposition said that the simulation should have been run in what's called an as-to-be-run state. Next slide. And again, so here are the factors. As you look at all these alternatives, think to yourself, were those other sites reasonable alternatives, or do they necessarily need to be excluded from the consideration because of technical or engineering feasibility, or they were locationally dependent to meet unique geographical needs that cannot be satisfied on other lands? And you consider cost, but that's not the only factor. Next slide. And so that's what it comes down to. Basically, as you go through and consider test one, it's important that you consider whether the defined objectives further the statutory purpose of providing a utility facility. You need to consider what evidence in the record you feel establishes that need, because that will then carry over to the next two tests, if that makes sense. And then and it kind of goes step by step. So if you feel that the applicant met step one, you go on to step two. If they met step two, you go on to step three. You can, in order to approve the application, they need to meet all three tests, and they need to ultimately eliminate all these alternative factors. If any of these things are not met, the burden's on the applicant, and the application should not be approved. Next slide. I think that's all I have. So I was here for questions. Yes.
First question, the alternate, I'm looking at the original application where it shows the 1, 2, 3, 4, 5, and then the proposed location inside of a box. And we never really got a full description of what location number 5 was, other than at some point, it almost on the map, it almost looks like it's like by the school or the church or.
We did. I forget which exhibit that's in. We did get
Okay.
coordinates for that, but yeah, originally it was just basically they copy and pasted the wrong one from 4 to 5, but that was rectified later on.
Okay. I don't remember seeing that. Okay. And then number 3 was because it's part of the HOA rules limited the height. If they, and that the HOA defines that they can't put a tower on there, if I remember correctly.
The applicant then said they were no longer considering the HOA prohibition to be effective, and so they then ran the tests, and then the tests showed that it would not be as effective as the main site.
Okay.
You guys can ask me any questions you want about the staff report or about the evidence in the record or about consideration.
I'm gonna have a question. I just got a few things to look over real quick.
Yes. Page 28 and 29 of the staff report go in a lot more detail on the alternative sites.
So John, on the search ring, originally in the first application, it was not submitted, correct? That's what Ferguson went over
That
that.
a focus zone that they were, but then the opposition said and so there was a focus zone. There were a few other, like I said, polygons that showed a ring type thing in the area. Opposition said, which one is the real one? And so then later, and I think Exhibit 211 is when they submitted, this is our official search ring. Verizon's expert Ferguson said that it was just kind of a goof, a mistake why it didn't get submitted originally, and that he wasn't the engineer in charge of the project at the time. And so the employee that was is no longer there. So he didn't have a solid explanation why it wasn't there, but it's there now.
And going over all the notes, I didn't see any comparison of a search ring similar. Like we didn't use another location to determine something similar geographically. See if that search ring's close to what it would be in a different area. Sorry, that was not clear. In this case, we're going over this one at Powell View. I was just curious on what other size search rings Verizon or other cell providers would have used in the past on similar situations geographically.
So I think that comes down to you guys as a finder of fact. If you think that search ring was appropriate, whether it was big enough. Like I said, the opposition argued that the search ring was too small, covering only 36 tax lots that are all on EFU ground. That is not what the Sprint PCS case envisioned as far as search rings go. Then the applicant countered that it has to be here because we have these two towers that are beaming right at each other, and so that's why it needed to be in that specific spot. Also because of the flatness of the terrain, and then the fact that McCoyne had then been turned down.
Thank you. You have any more questions for staff?
I have so many questions for staff.
We have plenty of time.
So we've already conceded that they meet the 215, 275 by providing a necessary service. Do we have to find that before a utility?
So they are a utility provider.
Okay.
This goes to the crux of the PCS case, which was the question of whether or not leasing to other carriers was, in effect, fulfilling the purpose of the statute, which is to provide utility service. So this is a utility provider. The question is this particular plan, does this further the goal of providing utility service in the region? The opposition would argue that turning down the existing three towers, they provide less coverage, and then putting more additional towers in the region goes against the thrust of that statute.
Okay. So we then have to determine if they've determined all reasonable alternatives. And by that, we need to go over what they have presented and what the applicant says, what the opposition says.
So broadly on test one, you're looking at factors such as the coverage and capacity needs. Are those legitimate? Did they provide evidence to establish there's a need there? Test number two, I would say, was the search ring a good faith effort and necessary to be there? Was the coverage objective area that was drawn, was that an appropriate size? And then on test number three, that's when you look at everything that's all the different alternative sites and if every single one of those should be excluded.
Okay, so then I have another question. If the applicant says the need is for capacity and coverage, and the opposition says, no, you don't. So we are to determine from the applicant's statements, and you're sifting through it, that there is a need because the opposition doesn't have Verizon's technical information to determine whether there is a need or not. Is that right?
You guys have a hard job. So, but yes. So one of the statements, I think it was in the final written argument, was that, no, I think it was in the rebuttal, that the applicant's experts should be given more credibility and should be more trusted because they were the only ones that have Verizon's underlying data that then goes to feed all the rest of these graphs and charts. And so with that, I think you can look at everything the applicant presented with that information. They do have the underlying data. You should also consider the credibility of them as well as the credibility of the opposition's experts, and the opposition's experts on opposition's experts' opinions on basically why the data presented was flawed or what else could have been done with the data. or why the ultimate conclusions themselves were wrong. And so this comes down to kind of who you believe and why you believe them. But I think what's important at one of the things that's important in step one, if you go into step two and step three, like I said, is, which evidence are you going to rely on to these next couple tests? And so, if the decision is that, the stuff submitted in the original application that had McCoyne at full blast, if that stuff's no longer relevant, then that shouldn't be part of your consideration for steps 2 and 3. If you feel like some of the maps in there were more persuasive than others, then those would be what you would lean on as you consider steps 2 and 3. But it's like I said, it's important to identify what you're basing your opinion on and why you believe that over the other stuff.
Okay, one more.
Yeah, and then Monty's next.
So the information that we've been given from everything, whether there's a need or which alternative site should have been considered or not, has been adjusted and changed and what do they call it? Bitch writer thing, and then what do they call it? Search ring is the right one. How tall towers should be, those kind of things. How much actual validity are we expected to be giving to one side or the other when personally I have no experience whatsoever with any of this other than, how to use my phone. So personally, my feeling is that the applicant's technical people probably carry more weight with their testimony than the opposition's people who came and testified, including engineers and whatever, probably should be given a little more weight because that's their job and that's what they do for a living all over everywhere, Oregon, I guess. And I remember the one gentleman who I believe had a engineering experience, but was retired. And he was helping out with this opposition because he had time on his hands. Now, to me, not that he doesn't have absolutely valid arguments, but maybe the opposition is doing it because they just don't like something about it. And I don't know whether it's the EFU land for sure or not, but I think they're trying to provide a utility service, and I think more weight should be given to the applicants. Or, when they did mess up, they right away cleared it up that something hadn't been done quite right. So
So
I'm thinking, can't we just say, yeah, they're a utility company and move on to talking about what are the alternatives that are do we have to do that?
So you should address all the arguments by the opposition. And like I said, some of these go directly to the Sprint's PCS case on whether or not they are furthering the statutory purpose. I would caution trying to read too far into the motives of the experts.
Okay.
I would focus on the data that's presented. But it does seem so the fact that Verizon, they're the only ones with access to that internal data, that's one thing. But the decision that you guys make needs to be based on the data that's presented in the record. That, some people might argue maybe that's not totally fair if only one side has access to that internal information. But regardless, it's your job to consider what has been presented and whether or not you think that evidence is credible.
Well, I do want to be fair, but I think some arguments have more weight than others.
Yeah, exactly.
Okay, never mind.
It's okay.
Do we have any more questions for staff? The commission will now determine if they'd like to make a motion to start deliberations or continue the deliberations to the next hearing.
I'll just remind you guys, before you make that decision, we do currently have a deadline of, I believe it's April 28th, to have the final decision rendered, including all local appeals. This is one where I would not expect it to be appealed to the Board of, I mean, it could be appealed to the Board of Commissioners, but I would not expect the Board of Commissioners to necessarily hear it, A, because of that deadline that's creeping up on us, and also because this is basically a statutory case. It's not our local code. With our local code, the Board of Commissioners gets a lot of deference in how to interpret it, but not with state statute. So there would not be a lot of merit to hearing it again. In addition, there's the de novo hearings, which means like new, so we would need to do this all over again. The Board of Commissioners, A, they're very busy, and B, this is a very thorough record you guys have built. So
Do we need a motion to move on to deliberations?
Yes, we do.
I would make a motion that we move on to deliberations.
I'll second.
Okay, we have a motion.
Hold on.
yeah, the motion should, it's our practice to, it's in there in your script to, there's different motions you can make to begin deliberations.
So
Um,
motion to approve or deny.
Basically, yeah.
Okay. I would make a motion to deny based on lack of evidence.
I'll second.
Okay, so we have a motion to deny by Commissioner Kurtz and seconded by Mike Warren. So now we're open for deliberations.
Yeah,
Let's
you guys
discuss
can
about it.
discuss.
Would you like to start?
Sure, I'll start. So I think on, as far as the, what is the service being provided? They're looking to increase capacity. I think that's pretty clear what their objective is. Is that, so I think that question one kind of answers itself. That one's pretty clear. Question two, have reasonable EFU alternatives, non-EFU alternatives been considered? I believe the answer is no, my opinion. In application, in the base application, pages 110 through 115, the submission, there are a number of locations. I believe 1 and 2 offer more coverage along Highway 126 than the proposed location. And I think that it's in combination. I think that, nowhere does anybody say they can't make use of one tower and then build a small, shorter tower. I know they ruled out PB20, which is alternative number 2, because of one reason or another, but there's nothing saying they can't go across the highway and use the BLM land, which there are reasons to support that. But they didn't bring that up, so.
I'd say that gets tricky because the statute, even though it's BLM land, even though it's owned by the federal government, it's still zoned by us as resource ground in case
Correct.
they ever went into private hands. And so by the plain wording of the statute, I don't know if that makes that eligible for the elimination of factors test that we have.
Okay. So as well, then I'll just stay with the PB20. I don't know that there was any contact to find out whether or not they could put it on there and apply for a taller tower. But I do believe alternates 1 and 2 offer a far greater solution in combination along Highway 126, which I also don't support the drive test data because it was, it's one piece of data, and a data set needs more than one piece of data in any case based on my own for averages. So typically you take 5, 10, 15, 20 data sets, and then you throw out the outliers, and then you take your average, and that kind of gives you some guidance. In this case, I think it was brought up a couple of times that was one time they went out there and took that data. We don't know if that was the best case or worst case. We just know that it was done one time. So I kind of find that hard to, I find it hard to justify the data that was presented in that case. So I think the other locations, should be reevaluated maybe in deeper depth to be able to avoid the EFU ground. And then number three, has it been eliminated due to technical feasibility or location geographical needs? I think that falls back to what I just stated. The drive test, I think, is inconclusive. And then the alternate site 1 and 2 both they both show better coverage for the main usage, which I think is probably the most important, is along Highway 126 versus north of 126.
Okay, so the applicant's asking for increased capacity, correct? For the
Correct.
bandwidth. Do you believe that they've made a good case that they need more capacity in Powell? And the reason why I'm saying that, because it goes with the
I think it's
driving
inconclusive because of the drive test data. And switching the towers midstream was a little shady. So I think that kind of threw the data set out. You can't trust when they're trying to, when anybody, and I don't care what it's for, if you're changing the game halfway through, or the rules halfway through the game or whatever, the data's no good.
Mhm.
So,
Well, that was brought up by the opposition.
right,
It was,
yes,
They
it was
didn't-
brought up by
They
the
didn't
opposition.
say that, hey, we changed this data and this is what it did to what we've provided you. It was brought up by the opposition and then had to be addressed.
And
that
as
correct?
both sides have said, when you have multiple towers like that, they describe it as a game of dominoes where, you raise some here, lower some there, and they kind of work back and forth. But yeah, also the applicant did state that they had plans to turn on McCoyne before they filed the application. And so you could make the statement that they should have presented the evidence with McCoyne turned down from the beginning.
And it's probably common practice in the field, but not described so that we understood what they were doing until they were called on it.
Right. And there's a note in there about Sprint Tower about being too tall and causing interference. And I believe it was brought up that they should just mount the new antennas lower on that tower to be more effective and less interfering. So I just, there's so much conflict in the data that was provided. And I think it was provided in a way that it was like, well, we're just going to push this through and it'll be fine. I don't trust the data.
And the search ring came out after the opposition came up alternative sites, correct?
Correct.
Oh. I would have liked to seen the search ring before we were going over different sites. Would have been a little bit more helpful.
It would have.
Yeah.
And the nowhere in anywhere does it, I know they're trying to keep it to one location, I'm sure for costs, but that can't be the sole defining factor which drives one location. I think that
I believe that was in the final rebuttal. Responding to that about multiple towers, they said that I think they said it was unnecessary and they're trying to limit the proliferation of towers in the county.
but adding one tower in a little bit different location and then adding to an existing tower doesn't proliferate. We're still at one tower being added.
I'm just telling you what's in the record.
Yeah. Okay.
Any of the commissioners on this side have any opinions?
Yeah,
Yeah.
well, and just for the record, I did listen to your entire video. I really enjoyed it. Thanks, John. So, but I
You're the only
think
one.
it gives you a little bit of different perspective to watch it from that side and listen to your guys' points rather than trying to think as everybody's talking, right? And which goes back, you said almost the similar thing in the video. Where I have the problem, which I think falls into a lot of these, is the conflicting data. It may or may not have been a big deal. To me, I thought it was a huge mistake as the CCNRs being from a totally different deal, even though they're not even considering that. I just felt some of the data put in place for us to make a decision, not knowing anything and only being corrected once called out, doesn't set the stage to put more weight on the applicant's information or data. I'm not saying it's wrong or right, but there's so many things. And I won't repeat what Monty said about, the whole turning towers down prior or whatever, but it just seems so inconclusive to take the data that we have in front of us and say, yeah, everything's good. And I mean, it just seems to be too many errors as far as I'm concerned, but that's my thoughts.
Kirk, you have any thoughts?
I'm ready to vote whenever you guys are ready.
I'd like to say.
Go ahead.
I'd like to say one thing. I'm a little, let's see. What's really throwing me off is the search ring being happening later than earlier, and then having all these sites coming up afterwards that were really never in the scope of the realm of the location of a new tower. To me, that just doesn't seem necessarily fair in how this process is being run. But it's kind of what my point is. I think I think we do need. I think there could be a capacity issue up in Palview, but looking at alternate sites really didn't seem to be possible after later on we ended up getting that little window of a search ring. If anybody else doesn't have an input.
Yeah, I personally, I reject the idea that this is the only possible location for siting. The reports provided do not adequately rule out all the other alternatives. And for me, there's too many discrepancies on how the tests were ran and how they were presented to us. Given the technological advances that are ever changing, and they're ever changing so quickly, I don't feel it would be a prudent move to make a permanent change on not only EFU land, but it's irrigated EFU. So Pal Butte, I mean, they're not wrong in saying that it's EFU land up there. We have to place on EFU land. I don't understand where the rulings come from. So I've read through multiple rulings that say they don't have to consider another EFU site, which I'm not following that theory, that thinking at all. I don't know how that came into existence. There's substantial EFU ground up there that's rock outcroppings. That's, the BLM rangeland. Yeah, I just don't understand where that ruling came from.
So I believe, just to answer your question, I guess that came from the ruling that came before the McCaw Communications versus Marion County. That is where I think the decision came out, and then that forced the legislature or encouraged the legislature to write the statute the way they did, and then so I think they then interpreted that wording to mean that EFU is EFU is EFU, and so
And it's not.
alternatives should be non-EFU. I think there's some case law where they said, "Oh, it'd be better on this EFU," and those were remanded by LUBA to be reconsidered. So it's important that we follow that, and that the alternatives that have not been eliminated are non-EFU. Would be in line with the case law.
I like what you read at the beginning, and I think we're going to need something like that to base the decision off of, correct? I mean, which one of these do we need to put in here to apply?
You guys have talked about multiple, I think, and so I would add, I guess, you guys should modify the motion at the end to include it's signed out of a meeting, and I'm going to take all your input right now, and then you see in the staff report they have the ultimate findings, and so the deliberations you guys have had will then be inserted into each of those findings, and so you don't need to, if the objective is to deny the application, it doesn't need to be for just one thing. It can be for, this wasn't good, this evidence wasn't credible, this wasn't good, and so those can all be part of the final decision.
Okay. I still like what she wrote about it. She didn't like the.
I have a couple of other
okay,
things that I
so-
wrote out too that
It's important. Yeah, I'd read them now if you have them.
Yeah.
So to me, the proposed tower is incompatible with the established character of the agricultural community, and it will significantly impact the aesthetic impact on the landscape and rural character of Pal Butte. So the applicant moved to Pal Butte 64 years ago. He is in the heart of Powell Butte. One of his exhibits states to the fact that should this ugly cell tower become a reality, then I have failed my goals. I am failing the goals myself if I place a tower on irrigated EFU ground. Just coming from a farmer agricultural standpoint is where my basis comes from.
I think that supports the intent of the statute. The statute saying if you want to place it on EFU ground, you can, but only if you look at every other option and eliminate them.
Yep. And so I think we've established that that has not been done.
We do not believe that
We
it
do
has
not
been not,
believe
we
that
do
it
not
has-
believe that they have met the intent of alternative ground.
Part of the we, I don't speak for everybody.
Yeah.
So specifically, you would take what has been said for the reasonings.
Should this vote pass, your discussion up there constitutes deliberations, and so that is going to go into the ultimate findings in the final decision.
We don't have to repeat it.
Please don't.
So, John, I have a question for you. If the original application were to propose a cell tower on non-EFU ground, downtown Powell Butte, would we be here?
It depends on the zone, whether it's an outright allowed use or a conditional use, but it's a whole different test.
Okay.
That shows the intent of the legislature where, like I said, if you want to put an EFU, you got to prove that has to be there.
Right.
Otherwise, then it's like any other structure, kind of, in compliance with the Federal Telecommunications Act.
I think downtown Powell Butte, that's a stretch.
You know what I mean?
John, would you like any clarification on the motion?
I think it could be a little bit more thorough and detailed, and then certainly adding the tidbit that the final decision will be signed out of a meeting, so just so we can keep with the timeline.
Okay. Yeah,
Because there's actually a motion on the.
right, there is motion. So Monty, if we want to add more to the motion, you'd have to rescind your motion.
Okay,
Or to make a new one.
okay, I'll rescind my motion
Rescind, just modifying it.
and modifying, okay.
Modifying.
Modify our motion.
And then does he have to re-speak on the motion?
Now you need to re-say it. Yeah.
You're gonna have to remember everything.
Okay, that's what I was asking. So I would move to deny the application due to inconclusive data showing that the capacity coverage needs are being met, as well as that I do not believe the search ring was sufficient. Oh, you're looking for that.
There you
Yeah.
go.
So inconclusive data, and the applicant has failed to sufficiently demonstrate that it has sufficiently considered reasonable alternatives to citing the utility facility in the exclusive farm use EFU 3 to provide service. Basically because the data doesn't show that. And I do not believe that the search ring was, they kind of rewrote the rules to make it that that's the only thing available as far as that piece goes. And there is insufficient evidence in the record to show that all reasonable alternatives on the non-resource ground have been fully considered and eliminated because the data shows that there's better uses along the highway for an existing tower as well as alternative 1 and alternative 2.
And I.
And to be signed out of a meeting.
His amendment.
And to be signed out of the meeting.
Okay, And I will second the amendment.
Okay. So motion is made by Commissioner Kurtz and seconded by Commissioner Warren. Open to, let's see. So now we can call for a vote. Yep. Kirk, Joe Vanini,
I deny.
George Pont,
No,
Laquita Stack,
No,
Well,
or so are you saying no? to
Yeah, so
motion?
the motion on the floor,
no to the motion.
Okay, and then Kirk, are you saying no to the motion? Or are you saying
Aye.
Aye.
You're saying aye.
Yeah.
Kirk Giovanini says aye. George Pont says nay.
Correct.
Laquita Stack,
nay,
Lonnie Kurtz,
Aye.
Marla Dill,
Aye.
Mike Warren.
aye.
Yeah. So the results state we have 4 for aye and 2 for nay. Motion passes by 4 to 2. Now we're moving on to public hearing. Record number 217-25-000-400-PLNG-GP LLC and Preday Family Ranches LLC owners and Quinn Burkett of Francis Hanson and Martin LLP agent are proposing an amendment to the Crook County Comprehensive Plan for an expansion to the aggregate and that's a good point. Yeah, we'll take
we're
a
going to take a
quick,
quick recess to
let's do a
let
quick recess. Thank you. Okay, so- Thanks for. We will come back at 5:10. Take a 4 to 5 minute break. We good? Okay. We'll now call the meeting back to order. Let's see, we are on public hearing. Record number 217-25-000-400 PLNG-GP LLC. Friday Family Ranches LLC owners and Quinn Burkett of Francis Hanson and Martin LLP, who's the agent, are proposing an amendment to the Crook County Comprehensive Plan for an expansion to the aggregate inventory. The requested amendment would expand the current permit boundary by approximately 4.1 acres to include the ends of the quarry floor to the northwest, southeast, and east. The subject property is located 15334 Northwest O'Neill Highway, Redmond, Oregon 97756, and is identified as map tax lot number 141-427-0000-100, which is 626 acres or 0.93 acres. And 141-434-000-1801, which is 109 acres, 0.92. The hearing is being held pursuant to Crook County Code 18.172, which is administration provisions. The Planning Commission will be evaluating the request against the following applicable criteria: Oregon statewide planning goals, Oregon administration and administrative rules, Chapter 660, Division 16, Crook County Comprehensive Plan Ordinance number 55, Comprehensive Plan Minerals and Aggregate Policies, and Ordinance number 43, Crook County Goals 5 Resources, Minerals and Aggregate Elements, to the extent consistent with ORD 51 and ORD 55. Crook County Code Chapter 18.16, Exclusive Farm Use Zones. Do any commission members have conflict of interest or bias to disclose?
No.
No,
So Rich Pridey was my dad's boss at Les Schwab's for my dad worked for, I think, 46 or 47 years. I've had my cows out there at Court's place, the place we're talking about. I've worked for him a lot throughout the last 30 years. It's not going to really affect how I'm going to vote, but I am personal friends with their family and they're really good community members, in my opinion.
Okay.
Commissioner Giovanni, can you be a little more specific than it's not really going to affect your vote? Can you please say whether or not you can be objective and give an impartial decision despite the relationship?
What you just said.
Okay, thank you.
I'd also disclose that I do real estate activities with the Pridays, both Court and Rich and Sandy. So nothing on this property, but it will not affect my decision whatsoever.
Mrs. Pridey tutored me when I was in kindergarten also. So I want to make sure we're thorough since we're doing the lawyer one.
Does anybody else have anything to disclose with the Fridays?
Nope.
Okay. Has any members of the commission had an ex parte contact with the applicant or any member of the public regarding this matter?
No.
No.
Commissioners should disclose if they visited the site and state on the record any observations and impressions from the site. Kirk Jovanini?
I've been up there, I think what you're talking about, and hauled some rocks out of there probably 4 or 5 years ago.
Okay.
And like I said, I did have my cows on the bottom part there for one winter,
How long ago was that?
3 winters ago.
Okay.
Mhm.
George Pont?
I have not been to the site.
Aquita Stack?
I don't believe I have ever been there.
Yeah. Mike Warren?
Only drove by.
Marla Dill?
I've not been to the site, but I know where it's at.
Lonnie Kurtz?
I have not been to the site.
And I have not been to the site. Are there members of the public in person or participating remotely who wish to challenge any members of the commission? If participating online, please enter in a request to speak using the chat feature. Nope. Hearing none, we'll move on. So we're going to order of proceedings. Before opening for testimony, either in person or for those participating remotely, I want to remind everyone that all testimony must be directed to the applicable approval criteria and standards. No person may testify without first receiving recognition from the hearing authority and stating their full name and address. No person may present irrelevant, immature material or unduly repetitious testimony or evidence. Please do not repeat testimony. Failure to raise an issue accompanied by statements or evidence with enough detail to give the hearing authority and the parties an opportunity to respond to the issue precludes appeal to the Land Use Board of Appeals on that issue. Failure to raise constitutional or other issues relating to proposed conditions of approval with detailed specificity to allow the hearing authority to respond to the issues precludes the applicant from seeking action for damages in circuit court. At the conclusion of the hearing, pursuant to Crook County Code 18.172.081, the Planning Commission may consider any request to continue the hearing or to leave the written record open. We'll start the hearing with a staff presentation. After that, testimony from any federal, state, or local agencies will be allowed. We'll then offer an opportunity for the applicant to speak. Individuals in support of the proposal will be heard, then those of neutral to the proposal, and next will be the individuals opposed to the proposal will be heard. The applicant may then offer a rebuttal. And if you have anything to say, please hand slips over to Hannah. Okay. And we will now proceed with the staff's presentation.
All right, again, for this record, this is John Eisler, Community Development Director, Crook County. The cell tower to a comprehensive plan amendment to add an aggregate site. Another one of these are going to be easy. And so this one, I just want to make sure at the outset, you guys understand you're not making a final decision. You're making a recommendation to the Board of Commissioners, who are the ones with the authority to actually change the comprehensive plan. And so this evidence will be presented again before the Board of Commissioners in at least 2 hearings. So this is the first step in a process. And then this does not enable the applicant to mine this area. It just puts it on our comprehensive plan maps and sets up what's called the program to achieve. And so before there can be any mining of the site, they'll need to go through the conditional use process. All right, thank you. Okay, so this proposal is to modify an existing site already in the county's aggregate inventory. I believe it has already been depleted, or at least it's been mined for many years. So this application is to add approximately 4.1 acres. The addition would include the ends of the quarry floor to the northwest, southeast, and east. And as I said a minute ago, if approved, the applicant has submitted their application for a conditional use permit to allow mining, crushing, and stockpiling. Broadly, that's where it is. So it's along a new highway right there along the Dry River in that red circle. Next slide, please. It's a closer view. And so the area we're talking about there is roughly where that circle is there at the bottom. That is the site plan submitted by the applicant. As you can see there, there's a couple more maps a little bit better that are coming through. Just give you an overview of what we're looking at. And so these are messy with the way things are written now. As I've mentioned to you guys, we're trying to update our goal 5 inventory and our rules, and this is one of the ones that needs to be fixed. And so we been enforcement order by DLCD back in 89 through the early 90s. And through that enforcement order, there are a series of ordinances that established how we are to process these aggregate applications. There is what's called a Division 16 rule, which is the old rule for Goal 5 resources that has been updated with Division 23. Without getting in the weeds too much, most jurisdictions now apply Division 23. Crook County has continued to apply Division 16 for reasons that are kind of beyond the scope of this. But so generally, and so there was a Luba case, went back and forth, the Hagley case that applied what we have now. And so that is what my prior hat advised the county to follow, was basically the way that the way that Luba went through our rules. And they lean mostly on Division 16, which is kind of what we mostly do. When there are gaps in how to apply things, that's when we then look to the Division 23 rules, which are the newer rules. All that's very confusing. Next slide, please. To simplify things, basically, there's 4 steps we go through that we've consistently gone through. And so step number 1, is this resource significant? Then you take a look at identifying any potential or existing conflicts. And then step 3 is what's called an EC analysis, where you analyze the economic, social, environmental, and energy consequences. And then finally, step 4, you develop what's called a program to achieve based on the prior 3 steps. So step number 1, is the resource significant? So we need to have sufficient locational information, which we do. For quality, we look to Ordinance 43 and Division 16. And so it takes a look at the material and ranks it from a 1 to a 4. 1 is the best. To be 1, it needs to meet ODOT standards for resistance to abrasion, sodium sulfate soundness, and air degradation. For quantity, like I said, we look to Division 23, is what we've historically done, which basically means if there is more than 500,000 tons of that material that's been ranked for quality, then that with those 3 things, location, quality, and quantity, you determine that the site is significant and should be placed on the map. For quality, so like I said, I believe 40 acres or so of the original site has been in our comprehensive plan for a while, and the quality of the material there was ranked as a 1. The applicant had Carlson testing. They took 3 5-gallon buckets of samples and got them tested. And all of those passed ODOT standards. And so according to our practice, that would qualify the quality of the material as a 1. Quantity, here's the map they presented. And so I believe the applicant can be more specific, but I believe the area we're talking about is here. They're trying to expand. So middle of this is the existing site, and that's where they're trying to expand. Next slide. And so again, I said there's a 500,000 ton threshold. The engineer's analysis was that there's a mineable volume of basalt rock material estimated to yield just under 725,000 cubic yards of rock. And then you do kind of a formula that basalt has an accepted density of approximately, you can read that there, 4,700 to 5,211 pounds per cubic yard of massive basalt. So you kind of multiply it by that factor there. And then so they multiplied it by 2.35 tons per yard, which comes out to 1.7 million tons of in-place basalt, which would be over the 500,000 ton threshold. So if there's necessary information to determine if it's significant, then you move on. And staff's recommendation is that there is sufficient information to determine that the resource there is significant. If there's no potential for conflicts, no existing conflicts, then it stays as a 1C site. But if there are conflicts, you move forward. So Moving forward to step 2, identifying conflicts. As I said, these are with existing or potential land uses that could conflict with the site. This part can get kind of confusing. This is from the case law from Luba. And so it's not about, there's being an aggregate site here that's going to kick up this dust and the neighbors aren't going to like it. That's not a conflict. It can become a conflict if we're trying to protect the resource site. Protecting the resource site with aggregate means you let them extract it, basically the maximum extent possible. And so if that dust coming then spurs neighbor complaints that then force a change in practice by the miner, then that's a conflict. And so you're looking at conflicts to the resource site, which can include kind of a bounce back of conflicts back towards the resource site, if that makes any sense at all, hopefully. If you guys want more information, back with my old hat, I did write a fairly thorough memo on a different one of these if you guys wanted that information, so you get kind of some background and historical context of how we apply these. But anyway, so the uses permitted outright in the area, farm dwellings, etc. The conditional uses you need to look at for potential conflicts, public and private schools, churches, commercial activities in conjunction with farm use, secondary farm dwellings, private and public parks, campgrounds, hunting preserves, home occupations, boarding horses for profit, non-farm dwellings, and personal use airports. So the applicant states that there are no dwellings near the expansion area. The closest structure to the proposed site is 3,000 feet away, and that mining has been going on at that site for many years. So the existing operation was determined to be a 3C site, which is the balancing, and so they put in place a 500-foot impact area with restrictions on the establishment of potential conflicting uses. Next slide. And so this is kind of the meat of this process. Typically, this is what's termed the EC analysis. And so where there are existing or potential conflicts, the county is to conduct an EC analysis to determine the economic, social, environmental, and energy consequences in an even-handed two-way analysis. And so you walk through each of these different areas where there could be conflicts. And so you look at the economic, you kind of look at the benefits and the burdens. The benefits stated by the applicant for economics is that it provides a local aggregate resource site, which is good for economic development. The burdens there, there's no evidence in the record of negative impacts to surrounding agriculture, but it could have negative impacts should conflicting uses move into and then exist in the vicinity. For social, the benefits there stated are improved quality of life through an increase in employment and tax revenue. The burden would be a reduction in the rural quality of life from dust, blasting, and traffic. For environmental, the benefit there was that it will reduce the number of truck trips from outside the region, bringing aggregate into Crook County for projects. The burden is that for environmental, there's potential impacts to wildlife. It's not a mapped wildlife area. There was originally a golden eagle nesting site, and so that will be addressed. And then, as usual, potential burdens to surface or groundwater. I think the applicant will have some statements to that effect, but I don't know how far away the groundwater is there, but the dry river there is not a perennial stream. For the energy and the benefit, the applicant states it'll save on fuel from having to truck in aggregate from elsewhere. The burden is that we will expend fuel locally in the form of running heavy equipment and processing material. And then statewide planning goals, those are kind of spelled out in the staff report. I don't need to run through these in this presentation. Next slide. So you get to step 4 then, which is to develop a program to achieve the goal. If the resource site is super important and conflicting uses shouldn't be anywhere near it, then you would term the site a 3A site. I don't know how many, if the county has any 3A sites. 3B means to allow conflicting uses fully, which would impact the resource site itself. And then 3C is the third option, which is we've often determined these sites to be 3C sites, which means you kind of do a balancing act between the resource site itself and existing or potential conflicting uses. Typically, that's done with a waiver of remonstrance with from neighbors that move in to get a use established where they're not able to then sue the resource site. It can also be done with conditions of approval as far as like hours of operation, that kind of thing with the neighboring sites. So next slide. So the program to achieve the goal that's in the staff report, it addresses some general concerns with information about the site plan, water rights, wildlife, fire protection, quality of life concerns with setbacks, traffic and access, dust mitigation, noise, operating hours, reclamation and water, and neighboring land uses with within the mining area and within the impact area. As I said, it would add conditions of approval to other uses and a waiver of remonstrance. Next slide. That's a quick rundown. Again, this is not going to be a final decision. This is going to be a recommendation to the Board of Commissioners for them to have 2 hearings, then make a final decision. The applicant has their presentation coming up next, but are there any questions for staff at this time?
I think you answered it. The only question I had is because in the past we've had them together, the conditional use, and
Yeah.
this is total, there's no conditional use tied to this right now.
So
I mean, not for the.
yeah, I'm not going to address it. We're probably doing it at the same time, but our code does say that if you a conditional use permit needs to be on the map, basically. It needs to already be on our comp plan if you're going to apply for a conditional use permit. And so when that was applied for, among other things, I said the application is incomplete for the conditional use permit because it's not on our map yet.
Okay.
And so that also helps with the timeline, right? So we have the shot clock on conditional use permits. And so that way we can get this resolved fully and then address the conditional use permit in a thorough process if necessary.
Okay.
And this might be a question for the agency, but how much of that 5,000 cubic the metric tons?
500,000 tons.
500,000 tons. How many years of rock would that be for this county, if you have any idea?
That would be a question for the applicant. So it depends on what you mean by, for this county, it depends on how quickly it's extracted and how fast it's getting shipped out and used. But 500,000 tons, I don't know. I think it was before your time, but we recently had, I guess I can reference, we had an application with Green Bar Excavation. That was, I think, a 10-acre site. 10 acres or 5 acres. But even with setbacks, they were able to meet that threshold. And so this is out of the OARs where it says basically anything that's not in the Willamette Valley, 500,000 tons and above is considered significant. That's the test we apply. As we go through our Goal 5 update, I might try to increase that because some of these sites are not, not super big. There's a lot of that are way, way over that 500,000 ton threshold.
Okay. Oh, thank you.
Yeah.
Okay. Now we'll hear from the agency representatives. If there's any agency representatives participating remotely who would like to offer testimony. Will it be online? Let's see.
I did have a question.
You
For you, since most of the truck licensing, I guess Kirk could probably speak to this too, but like if you have a semi truck, you're paying by mileage for your plate registration. How does that get trickled down to county roads and maintenance and costs and things like that when you increase the impact to something like that?
No.
My understanding is currently there is nothing in place for that. I can tell you that out of Oregon counties, Columbia County has kind of a service fee or like a shipping fee. But currently in Crook County, there is nothing in place for that.
Okay.
Yeah, but time limit.
Yeah. We didn't hear from anybody from the agency. Okay. Does the applicant wish to testify? Please be sure to state your name and address for the record.
Hello, Quinn Burkett for the applicant, commissioners. And address,
And address.
1148 Northwest Hill Street, Bend, Oregon, 97703.
Thank you.
How are you? Well, I don't want to belabor the point too much, obviously here to answer questions that we can. We also brought an engineer who helped us with our report, Jim Newton, who can get into more technical details about water usage, that sort of thing. I did think it might be helpful just to offer a little bit more background on what it is that we are trying to do here. So the ownership of the whole pit, as we call it, changed hands in 2021, and up until that point, to my understanding, it was still in active use as a pit. And upon the ownership changing hands, it was discovered that there were areas outside of the then existing permit boundary to the northwest, southeast, and east of that permit boundary. And so in order to ensure that we are in compliance with both state regulations and county code, we are trying to come back and just have those permit boundaries extended to those pre-disturbed areas. I would also like to note that those areas that have been pre-disturbed, especially to the northwest and southeast, we don't anticipate more mining activity going on there. Those are essentially work floors. Furthermore, the closest residence that I could see to the pit actually belongs to the son of the manager for GPLLC. That's Court Friday. And so again, don't anticipate issues with him. And as well as the fact that I am not aware, and neither is my client, of any complaints relating to prior mining that took place there. I think something that's important to note for the commission is that the location of the pit is in a natural canyon area, so that helps to mitigate sound. It's also about a mile away from O'Neill Highway, so in terms of public thoroughfares, it's screened from sight. Against sound, I think that helps with dust mitigation. That said, after reading the staff report, we're open to hydro seeding, working with the county to make sure that we're mitigating any sort of negative consequences that could come from resuming mining operations once we get into compliance with county code and state regulation.
Well, you kind of answered my question because you talked about the violation. So I was trying to read through those real quick. Was there any fines, or did you guys were able to just rectify it
It was in as far as the
of doing it outside the boundary?
I'm not aware of any fines that have actually been levied. However, we've been in contact with Dogami, and I think that, you know, the owners here want to make sure that should mining operations resume, that we're doing it above board and in compliance with the rules. So I think this is more us being proactive rather than reactive in that regard.
Okay. And the other question I had is the testing with the said some. I didn't see a date. Maybe it was on there, but I didn't notice it. What?
For the quality and quantity?
Yeah.
I'm happy to defer to a
Okay.
more seasoned hand in that regard than myself.
That's fine.
Yeah, I mean, Jim Newton can speak to the quality and quantity analysis that he conducted. He'd be the better person to hear from on that front.
Okay. That's all I had.
Have any more questions for commissioners?
No.
I sort of had one. One of them was the quality, but I guess he'll answer that. The stuff that was done before when it was approved in 1995, and they were the seeded berms that were to be around it. Are those the things that got disturbed?
No, Commissioner. So those seeded berms, there's a 2 to 3 foot berm that exists between the working floor and the dry river. It's
Yep.
an intermittent dry river. It's irrigation runoff. And those are still in existence. Those are still there. I was simply suggesting that when the time comes for reclamation, and even during the course of mining operations, should they resume, you know, we can do hydro seeding to make sure that we, you know, improve the riparian areas between the working floor and the dry river. I think that's, John was showing y'all a map earlier of kind of where we were trying to expand.
Yes.
And the mine itself, or the pit itself, the aggregate that would be being extracted is on the eastern side of the pit. And so thank you, Hannah. Yeah, so right up in, so it's there, and then also like all essentially that whole upper right area as well is all the pit itself down by the road where you can see, and then there's kind of strange jutting outs. Those were the areas that were pre-disturbed, as with the far eastern portion. Those are working floors. No additional mining operation is expected to be taking place there simply because no aggregate exists right there.
Okay, thank you.
You're welcome.
And pertaining to this map on the bottom left right there, is that where the canal, there is a canal that runs
Right.
through there, correct?
That's where the dry river would be.
Dry River.
That's irrigation runoff, no fisheries or anything in that area.
Okay, thank you.
Welcome.
Yep, okay.
Oh,
Um,
one minute. Part of this, because of the change in what used to be a 3C is now a 1C. Is that part of the rationale for?
I mean, John, I'm happy to speak to what I believe the staff report said, but I think that the significance of the site could constitute a 1C designation. However, because there are existing or potential conflicts when the EC analysis was done, that more appropriate would be a 3C categorization. And that's how I read the rule.
Oh, so. Question for John.
Possibly.
So the EC evaluation from the original thing, is that now a totally different thing because time has gone by?
No, so the original ultimate conclusion was it's a 3C site with the balancing.
Okay,
I'll just add to, I guess, because it's relevant on the water stuff. So the applicant had an engineer submit, there's a lot of technical stuff that was submitted later, but it was submitted as a requirement for the conditional use permit. And so a lot of that has been addressed and is addressed, but that's not part of this application. It's not a requirement for the comp plan amendment, just to put it on the map. But as far as, water concerns and that kind of stuff, that can be more appropriately addressed in the conditional use permit process. Get there.
can I ask one more question? So if it is basically good stuff and there's 1.7 million tons of it there, is all of that in the 4.1 acres of extension?
Again, I would probably defer to Jim Newton on this, but I do not believe that is the case. I think that 1.7 million tons is taking into account the entirety of the
The
site.
site, yeah.
However, in order to ensure that we're in compliance, we need to extend the existing permit boundary out
Okay.
to what's already been disturbed.
I think Jim's got an opinion
Yeah,
on this, just shaking his head. A different opinion.
we can see his expression when you're talking.
Yeah, okay. Thank you.
Oh, good.
All right, any more questions? Not, does Jim want to come up and speak?
Thank you all.
Oh, thank you.
Hi, Jim Newton, Cascade Geoengineering, 21145 Scottsdale Drive, Bend, Oregon, 97701. I guess the state qualifications, I'm an Oregon licensed and practicing professional geologist, professional civil engineer, and certified water right examiner. So I was the one that has prepared the quantity and quality analysis. I've also prepared as John referenced recently, directly to the county code report that's meant more for the CUP process, but I think it's in your guys' section as well. I guess a quick question, I kind of tried to write down the questions I think that needed to be answered, or do you guys want to restate any questions that Quinn wasn't able to get to?
I just have one clarification.
We have one clarification question.
And I have to apologize because it was the very last 2 pages of the report, but I see the date of the Carlson test.
Oh, yeah, yeah.
So that was my question, but
I had that in mind.
okay.
Joe, if you'd like to start on any of the questions, and we can ask you more here in a second.
Sure. So a few of the questions, at least that I had written down that I think probably would be helpful. And actually, if you have the slide that has the site map, we'll probably use that reference a few different times. Is it possible to zoom it up a little bit? So when you look at this map, the kind of the primary expansion area that's really intended for the mining, where that 1.7 million tons value comes from, is when you look at, the top of the point. So most of it comes from that northwest boundary and that's northeast boundary, kind of what looks like the top of the roof, the lines of a roof there, inverted A or inverted V. So the area to the southwest, that kind of meandering line there a bit, that's essentially the cliff, the edge of the cliff and the floor of the basalt. So the way the cliff side is when you look about, if you're standing down along Dry River and you're looking at the cliff, about the bottom 2/3 is, and it's referenced in that quantity quality report, about that bottom 2/3 of the cliff is like an ash tuff. So it's not really the target material. It was referenced in that as a material that does not meet ODOT base spec. And then the upper third is that basalt material. That's the stuff, that's the good stuff, right? That's the ODOT base rock spec. So in the area that's been currently mined, they've pretty much mined what's likely to the bottom of that basalt or the top of the ash stuff. Rather than me get into the nitty gritty and start drilling and trying to pick up every little piece, I just assumed that when I had the surveyors come in, they surveyed the floor and we just called that good. No, without the intent or need to go down, that the likely additional mining area would be to the northeast and the northwest. So you literally just taking that big A and moving it out a little bit. So that's where the material comes in. And so it's not looking to necessarily go down at all in the quarry. That value comes from, essentially expanding that northeast and northwest boundaries, and just extending and chasing that material. So when we took the samples, and I think Michael, you may have asked that question as well. I took the samples from 3 different locations. I took it from essentially the northeast wall, the northwest wall, and then actually took one from about 2/3 up from the work floor. There's a bit of a hump that kind of shows up in the topo, and dug down and got kind of native material. So we got 3 good samples, and those were all run together, and all that material passed with flying colors, right? So we met the ODOT base spec. That had kind of addressed a couple of questions. Let's see. So in reference to the berms, you'd asked about, LaQuinta, you'd asked about the berms and potential disturbance areas.
Yes.
So the berms that were constructed, and I guess just to back up, Steve, the advantage to a site like this is that you're not think of it as standing at O'Neill Highway going into a cliff. You're not doing that, right? You're kind of, the canyon meanders a bit. So you're out of sight, out of mind. And then when you're actually on the plateau, the quarry's going down. So you're not creating an eyesore, but also any noise that's generated is kind of below the horizon, right? So out of sight, out of mind also means that noise doesn't travel very well because you're actually mining below grade, which has an advantage, also has an advantage with dust and everything, right? So those berms for mining are typically erected in an area where you're trying to screen from a visual. So because of the mine going down from that upper area, that plateau area, there's no need for berms there. So you essentially leave that setback area as undisturbed. So typically in a setback area, you're allowed to build berms. In this case, there's no berms there. There wouldn't be a need for berms in the future. So the berms that are existing are the ones that essentially parallel Dry River, and then corral the site to the southeast. So that way, a bunch of advantages there, right? So having the berm between the work floor and Dry River shows that you're able to control any stormwater that could migrate towards Dry River and create flow in the river or in the canyon. And you're able to contain it on the site. You're also, by having a berm on the southeast end, any just kind of stormwater runoff that may try to infiltrate and go onto the site and then pick up sediment, then it essentially gets stopped and gets diverted into Dry River. So essentially you're able to keep any errant material from leaving the site because you have berms on those 2 locations. And those are areas, one, we're not looking to expand into those areas, mainly because there's not mineable material there. and there's sufficient work floor with what's already there, that there's no reason to expand that. So those berms not only are there, they would remain, and then they would be essentially maintained. So, and maintenance by, they wouldn't necessarily need to be added to. But, one thing that's very common with mine sites like this as well is, you want to control what you can control. So dust is one that you can control. Having vegetated berms or things like that in areas that are going to maintain vegetation, those are perfect locations that, as you would get started, you would seed those, because and you use a native mix so that that any material you put down from seed, hydroseed, is going to take, and it doesn't need to be watered, right? Because if you're using native material, it's going to take care of it all on its own. Let's see. I think that addressed the question that you had. Let's see. And I think between Quinn and maybe that last question, that addressed the question that you had, Hunter, about where the questions about Dry River and the berms and things like that. Let's see. When we get down to I think we also addressed, LaQuinte, some of your last questions were related to where the 1.7 million tons would be coming from.
Yes.
Talk about that.
Yes.
Did that sufficiently answer your questions?
Yes.
Okay. And then I guess I just had a water concern with question mark. John kind of, I think, heard it, but it got me. You got questions about it, we can talk about it. So if I did include in the report.
Including the report, it was labeled for the record number for the CUP, so I did not include it in this
Okay.
application. If you guys want that included in, if you guys don't object, we could include that in the record for this, but I was thinking we would then say that that issue has not really been addressed in this process, and then would be addressed fully in the conditional use permit.
That wouldn't really have any bearing on it being a.
No, it doesn't have any bearing if it should be on the map or not. It
But
would
it
just,
would be
it
on
would
a
go
conditional
into,
use.
yeah, it's,
Okay.
so the issue is that the way our code is written, for aggregate mining in 18144, it says that basically any issues addressed in the pop-up process then apply to the conditional use permit. So you don't have to do it twice. So I just want to make sure that, we're clear that those issues were not addressed now, or if they are, that we address them fully. And I want to make sure we don't brush over them, and then assume on the CUP they've been taken care of.
Yeah, I got you.
Does anybody have questions? Commissioners? No? Well, thank you, Jim.
Yeah.
Yeah. Is there anybody else here in person who would like to testify in support or in favor or in support?
In favor or against either one.
Are you neutral?
Is it-
Okay, that'll be next. Is there anyone here in person who'd like to testify who's neutral?
Julie Thompson, Green Valley Road in Prineville. I just had a question with your presentation about the environmental benefits, where this 500,000 tons or more would be for Crook County. Are we guaranteed it will stay in Crook County? Because like Monty brought up, the roads, we get no money for that. We've got the traffic. But it's my understanding that most of our aggregate product goes to Deschutes County, and where it's really right on the line of Deschutes County. That worries me.
Yeah, so that information I think was provided by the applicant, that representation. And you are correct, a lot of the aggregate in Crook County gets exported, which goes to a good question that I think was it Monty about the roads, and that's can't speak out of turn, but that's something to look at.
So there's no real answer to it.
There's certainly no guarantee, as far as I know, in the application or from the applicant that everything extracted would stay within Crook County.
Is there anybody else who is in support or who is neutral, that is remote or here? Nope. Very good. Is there anybody here in person who'd like to testify in opposition? Is there anybody participating remotely who'd like to testify in opposition? Okay, the applicant like to offer a rebuttal testimony.
Just briefly, I think that the statement that aggregate would stay in Crook County wasn't meant to say that it's only locked in here. I think that it's obviously going to go to where any sort of need arises, but should development needs exist in Crook County, it would make sense that it's a great site to pull aggregate from.
Yeah, that's fair. I think maybe I can wordsmith that better. It goes to the Board of Commissioners.
Well, just a comment on that. Unless we had a batch plant for asphalt here, isn't it kind of irrelevant? I mean, the money, I don't know how I want to say this, the rock itself may not be for Crook County roads, but it's bringing employment and funds into Crook County.
That goes to, sorry, I'll answer that. That goes to the economic benefits. That's, if there's someone working here in Crook County, that's a pretty direct benefit to the county.
Well, we don't keep our cattle here. We don't keep our hay here. I mean, can't tell somebody where they can keep their resources.
The EC analysis is.
That's assuming they live in Crook County and not in Deschutes County.
Yep.
Yeah.
Yep.
Do we have any more questions for the applicant's rebuttal?
No.
Okay. Does the staff have any other comments in response to testimony or evidence offered?
I don't think so, unless, like I said, unless you guys want to address the second report that Jim Newton supplied that is part of the conditional use permit process, then I think everything else has been addressed. Unless you have any other questions.
I actually like what you stated before. Instead of talking about any of that for the permit, I think we should go through the process. So it either doesn't get missed or doesn't get put in one way or the other. So.
Okay, does anyone ask to continue the hearing or request that the record be left open?
Sorry,
Alright.
the record will be open at the Board of Commissioners, and so
Right, okay.
you guys be closing the record for your recommendation, but it would be open again at the Board of Commissioners.
That would make sense. Okay. So the commission will now determine if the hearing should be closed or continued to a time and date certain either for additional testimony, additional information from staff, or for deliberation only. So does anybody have?
Mr. Chair,
Hmm?
I move to close the hearing and request the chair ask for a motion to begin deliberations.
Second.
Okay, we have a motion made by George Pont and seconded by Laquita Steck to move and close the hearing. Requested move to deliberations. I'm sorry, guys. I'm falling asleep here. Where we at now? I was trying. Sorry, I lost train of
I
thought.
call for a vote.
Yep.
Call for a vote to close the record.
Alright, yeah. Okay, so now I call the commissioners for a vote. George,
Aye.
Kirk,
Aye.
Mike,
Aye.
Laquita,
Aye.
Monty,
Aye.
Marlo.
Aye.
Okay, that would be a unanimous vote to close the hearing. Thank you.
Okay, Chair. So I would
There we go.
make a motion to approve. I move that the Planning Commission recommend approval to the Board of County Commissioners of application 217-25-0004000 PLNG based on the findings of fact and conclusions of law contained in the staff report and as presented in exhibits and testimony. I find that the applicant has met their burden of proof for all applicable criteria specifically.
I'll
Second.
second.
So we have a motion to approve by Warren, seconded by Marlo Dill with conditions stated. After deliberations, restate the motion to approve and deny include specific revisions of the motion. So we're going to call to a vote, correct? Okay, Kirk Jovenini,
Aye.
George Pont,
Aye.
Quita Stack,
Aye.
Mike Warren,
Aye.
Marlo Dill,
Aye.
Lonnie Kurtz,
Aye.
and aye. The votes state is unanimous for aye. Now we're going to move on to community development updates.
Mike, how long have you waited to actually make?
I can bring that back, or they already made the motion, made the vote. Let's bring it back to, we can put on the consent agenda. Oh.
You're up.
I'm up.
Hey. We're all-
Chair Newworth, I too am tired. We have an update. So last time we went over the numbers we have for the department. We don't have any numbers for you there. There's no change with, Hidden Canyon applications coming up. Still waiting on DLCD for the Goal 5 update grant contract so we can get that moving. I do anticipate having the recommendation for the Knife River potential modification revocation at our next hearing. Hannah has been displaced. They are working in our offices to remediate some moisture issues. I also want to make sure that it's known that Hannah is under the weather, and she is a serious trooper for being here tonight and making sure this meeting could be run properly. We're going through budget season right now. We're adjusting the fee schedule. Busy, but I'm tired. Not a lot of new stuff to update you guys with.
That season, the days are a little bit longer and you just cram more into.
Yeah.
Yeah, right.
Well, so, any further business to come before the commission this evening?
Is I see this, so the next meeting is the 22nd. I take it you highlighted this just in case.
We couldn't have nothing scheduled for April 8th.
Okay.
Okay. So hearing none, I'd like to thank the staff and public for participating.
That was the request. So if you remember at the last hearing, we had the request from Central Oregon Land Watch to initiate a modification revocation proceeding. And so my recommendation was to wait for a staff report on that issue. And so that's what would be presented at the next hearing. I speak too fast a lot of the time. Sorry for that. I'm with you.
Yep. Our next meeting will be held on April 22nd, 2026, 4 p.m. here at the Crook County Annex Building. There being no further business, there is a motion to close the meeting.
So moved.
Second. All in favor?
All right.
Aye. Okay, meeting's now adjourned. Time is 6:02.